Okay. Good afternoon. Welcome back to the post-lunch session. We really have two very interesting sessions today, and I'm sure you all would be highly benefited by these two sessions. The first session will be taken by Dr. Dhananjay Kalvande sir. He is a distinguished academic and technology innovator, serving as professor and head of the Department of Computer Engineering at Sardar Patel Institute of Technology, University of Mumbai. With more than 22 years of teaching, administrative and research experience, he holds a BE in Computer Engineering, a ME in Information Technology, and earned his PhD in Technology from the University of Mumbai. His postdoctoral work at Tata Institute of Social Sciences focused on gender-inclusive technologies and social impact research. A prolific researcher, he has authored over 130 peer-reviewed publications, edited 6 technical books, and supervised numerous PhD scholars. His area of expertise are artificial intelligence and soft computing, human-machine interaction, IoT applications and digital forensics, AI in healthcare and security, open source software licensing. Dr. Kalvande's work sits at the intersection of emerging AI technologies and digital IP challenges, making him uniquely qualified to lead the discussion on AI and IP implications and nuances of open source license in innovations ecosystems. His professional highlights are Head of Computer Engineering, Dean of Industry Relations, Postdoctoral Fellow, and recipient of research grants from UGC, DST, NSTBD, and SPIT. Served as IDC Advisor, IIC Chair, and E-Cell President at SPIT. Some of his notable contributions include applications of deep learning for smart healthcare systems, integration of HMI and IoT for adaptive systems and forensic analysis in digital environments. Dr. Kalvande brings an exceptional blend of technical expertise, academic leadership, and ongoing research, making his session a valuable opportunity to explore the legal and technical dimensions of AI, open source software, and intellectual property. I request sir to take over the session.
Good afternoon, everyone. I understand after lunch it's very difficult to listen to someone rather than listening to music. Sometimes music gives the good sleep, correct? Rather than listening to someone. I do understand and respect your valuable time. So, I am presenting here on the topic emerging issues, AI, artificial intelligence, and IP, intellectual property, and open source licensing. The outline of my presentation will be covering fundamentals of intellectual property, AI's disruption of IP, open source, licensing risks, mitigation and future outlook, and then questions and answers. Look at this first, this I had taken it from a ChatGPT from these 3 keywords. The 3 keywords which I had used, emerging issues, AI and IP, open source licensing. In today's digital world, there is nothing secret as it is. Your human brain cannot be compared, even though ChatGPT and so many bots came, but human brain remains as a human brain. There is no superset. Technologies or today's AI, even though you thought of inventing something, you cannot replace someone human brains with ChatGPT. Yes, you cannot replace. You can make multiple ChatGPTs, but you can't prepare, you can't mimic. You can mimic, but you can't replicate it. Only you can prepare the ChatGPT like the human brain works, like the human being thinks. I think from this you can conclude there is no substitution in this universe. There is no substitution in this universe for the human brain. So today's AI or any particular technology need to learn as an assistant for solving a particular problem. You can't say today's artificial intelligence, today's robotics, today's robots are the replacement to the human being. They are not. They are not substituting anybody's standard practices. Rather, they are just adding the assistance in day-to-day activities. They are helping to doctors for operation. They are helping to the engineer at the manufacturing industry to precisely calculate the area for a particular cut. They are helping to so many industries agile today. They are nothing but that means we should look it as a assistant. So this is what is one, because the word, it starts with the word artificial intelligence. Today's ChatGPT, if you ask and say ChatGPT, give me best 5 innovative ideas in, now the title should be yours. The ChatGPT, based on the records, based on the textbooks on which it is trained, will definitely capable to give you the 5 best topics. Now if you get in Indian settings, so they may search for all those texts available in Indian settings. You can ask them what should be the best innovative, what should be the best innovative way in, say for example, today's anxiety and stress are increasing day by day. So we had studied that the old age population is increasing day by day. Even after pandemic, most of the times the education happens in an online mode, most of the times. But pandemic helps all of us to understand how to use the Google Meet. Many people understand how to use Zoom, how to use Google Meet, how to use the tools and technologies. That is an advantage. But apart from it, the adaptability to use these online resources are also increased, which causes to increase the anxiety and the stress. Due to this anxiety and stress, not only in the youngster, but also at the middle age and the elderly people, it causes. This is what is my study. I am saying since from 6 months I am studying one particular point to be studied, that is what, how can AI with the help of other tools and techniques will be able to detect the early stage of dementia. I think many of you know the dementia. Many of you know the dementia. Many of us knows. Sometimes we, अरे यार याद नहीं है. Many times in the home, oh यार मैं भूल गया हो. Oh, I don't remember. So many things. Many times it happens with each and everyone. It happens with each and everyone. Just one news came that the dementia can be identified. AIIMS neurosurgeon suggests dementia start with the legs. 4 signs, one might be at the risk. Dementia starts with the leg, L-E-G. सोचो क्या हो सकता है? You can come up with those innovations, you can come up with those IoT enabled tools and techniques which can be powered by your own customized artificial intelligence algorithm, machine learning algorithm, deep learning algorithm with the help of computer vision methods, and design that device which may definitely understand the early stage features from the gesture, from the talks, from the communication space, audio, video. It is a multimodal, it may be a multimodal fusion model. It may be a multimodal fusion model to at least detect the early stage of the particular disease. That is supposed to be the innovation where the solution is going to be happen, whether it is really going to be success or not. So this is nothing but called as an actual research problem statement. Otherwise, in today's days, what's happened? Okay, AI model for predicting crop disease, AI model for predicting this particular, AI model for spam detection, AI model for that garbage. Okay, so you can think of it which is already available, but you are not putting your brain and thinking whether it is really going for a patent or not. This is I am discussing with you because the session is on intellectual property rights, on copyright, on IPR, how to file the patent, what are the issues, are you really means doing a particular project means directly you can publish. What happens in Indian patent side, you can publish as many you want, but you will get a grant only if it is really innovative. And to get the grant in Indian settings, it's really a big task. It's really big task. I will show you one patent for which I had drafted, means me and my student, I means we had drafted, and without any hearing, without any file examination report, without filing any single examination report, the patent is granted. It is in association with KM Hospital plus my PhD student from Sadomal Shani and myself. Without any hearing, it's happened. Many patents, there is a hearing, but many times whether it's possible for the controller to justify, it's very difficult. It's very difficult to understand, yes, this is my innovation, yes, this is what is the work which I would like to say that this is what is something new. Patent is granted on particular product, patent is granted on particular innovative design. But today's many times you may see algorithm is already exist, and someone won't directly say the algorithm and say this is what my algorithm, it is used for this particular, maybe that particular problem statement may be different, but existing algorithm if you apply on solving a particular problem, that is not supposed to be filed as a patent or as a copyright. About this, I told you that I am giving due citations to the chat GPT. Just before 3 hours back, I used this keyword and say give me brief, give me at least brief, because audience just I learned from the sir that audience is from different backgrounds. So say this is very generic definition, AI generated content and ownership. When AI creates music, art or inventions, it is unclear who owns the IP. It's very simple from the sentence. जब AI create कर रहा है music, art और invention को, it is unclear who owns the IP. User करेगा, AI developer करेगा और no one. Correct? Patent challenges, that is AI generated content and ownership. It's not clear. It is completely, no one can take a decision. अगर आप AI tools use करके अगर कुछ कर रहे हो, that means it is nothing yours. Okay? Patent challenges, AI can help invent products. AI can extract all those contents from the available resources, can help inventing the products. I have just told you one example of the dementia. It is one of the new thing. There are so many other topics available. There are so many. See, while walking on the road, there are so many potholes I have observed. Might be we do not, the BMC do not have the concept of having the web camera connected to the moving vehicles and take the photographs of the particular you can say the path from source A to source B, and those particular web camera is not so much capable to detect the depth of the pothole, can detect the circular patches, count the number of potholes, these many number of potholes will be there. Depends on the number of potholes. Is it not possible to calculate how much material will be required to repair it? It is possible. Someone should come up with this idea. Someone should automate this idea. If it is not there, can this is possible or not? So ideas should come from such kind of experiences only. You need not to read. You need to understand, observe and take an experience. From this class, you may have a web camera, and from the web camera, from your gestures, whether you are smiling, whether you are in some different mood, whether different types of moods are there. Personal traits can be identified. Someone is in the sleeping mode, someone is in the happy mode, someone is thinking over thought, someone is just enjoying, someone is just forgot कि क्या बोल रहा है. Patent challenges, AI can help invent products, but patent laws usually require human inventor. There is a human who is involved, and in Indian settings, patent laws usually require the human inventor. There is no AI. अगर AI based patent granting चालू हो गया, I think बहुत सारे लोगों को patent मिल जाएगा. Still AI office, still patent office doesn't have the use of artificial intelligence, and if they apply artificial intelligence, might be it is possible to get the patent release the patent as early as possible. I myself has given the hearing of 4 patents out of 8 patents, I received 3 Indian patent and 2 German patent, 3 trademarks and 2 copyrights. What is the pain? I know. How much the amount has to be invested sometime, because you need to file. The government charges are 9,100 only, but rather on you need to submit the report sometimes. Okay, it's very difficult to get this. Sometimes it gets abandoned. If you don't reply, people what mistakes we normally do, we just filed it and बोल देते the patent is published. But क्यों publish कर रहे हो? Why? What is the motto? If you do not want the patent granted, do not publish it. Do not waste your time. If you really have a confidence that I should get this patent, then only file it. Otherwise, don't file it. Unnecessarily wastage of money.
Copyright concerns. So training artificial intelligence on existing copyrighted content. So that's a concern. Example, you cannot directly say something, you can read from the books and you identify that it can be copyright. No. So it raises the questions about copyright infringement. So this need to be avoided. Ethical and legal debates, governments and organizations are still forming the policies on how this artificial intelligence fits into the existing intellectual property frameworks. They are just thinking, even I think in the High Court, people's advocates started using artificial intelligence for understanding why the cases are still yet pending. AI helped them to understand why this particular case was pending from so many days. And that's why High Court, I think they had allowed. During pandemic, there was very strict, earlier there was a very strict telemedicine law. And then when pandemic came, the doctor who hates AI, who hates online, who hates WhatsApp, started using online consultation of the patient. Is it the true? Yes or no? Yes, it's a fact. During those days, pandemic has opened up the eye. AI is not your substitute, but AI helping you as an assistant. But again, the same scenario is continuing. It is not very close to their heart. AI has reached to that level where AI helps in identifying those particular positions for detecting the tumors. AI helps, the robots are helping to get precise area where that particular cut can be happened. To whom this all is going to be benefited? To the human being only. In cancer cell detection, detecting pneumonia from your X-ray images, so many things. From the legs, from the foot care images, you can detect early stage of diabetics. I am working with KEM Physiotherapy Department, Dr. Maria, working since from 1.5 years, collected 700 images, and yet it is possible to detect the early stage of diabetics from the foot care image. पायाच्या फोटोवरनं diabeticsचा early stage ओळखायचा. We had filed the patent and we received the patent because it was completely new. The application is not uploaded on the Play Store. It is there, and Dr. Madam is going to use it for the cause for which this project started, to help their patient from the remote places. Okay. So this law, how AI fits into existing IPR framework, the process, it is still under process, and the patent office may think of defining the policy for using the artificial intelligence for hygienists. About the open source licensing, this keyword is a software whose source code is freely available for use, modification and distribution, like Linux, and there are so many open source like Python. These are open sources. There are so many open sources softwares available which you can use, you can modify, you can redistribute, and there is no concepts. The particular new innovative things which you are developing using some open source, that will not, you can say, we are not following the law. It is possible, it is allowed. But somewhere permissive license like MIT Apache 2.0, it allows free use and commercial distribution with minimal restrictions. They say you can use it, but with some minimal restriction. Copyleft licenses like GPL require derivative works to also remain the open source. Okay, so this is all moving to this is the brief of the today's presentation. Let's move to the next part, intellectual property rights. So the world's first patent was granted in 1790 to Samuel Hopkins in USA for making of pot ash and pearl ash by a new apparatus and the process. This was the first patent, world first patent. In India, the first patent known as exclusive privileges at that time was awarded in 1856 to a civil engineer George Alfred D. Penning from Calcutta for his invention an efficient puka pulling machine. Okay, these are some history. Why now discuss this intellectual property rights? See, the example I told you, the US company was awarded a patent for neem as a pesticide. Where the neem कहाँ होता है सबसे ज़्यादा, कहाँ पे इसका origin? इंडिया में. Patent किधर है? Yes. Second example देखिए, CSIR. Everybody knows what is CSIR. हाँ. So Pune based CSIR successfully forced US Patent Office to revoke a patent of powdered turmeric for wound healing. Everybody knows the use of turmeric for healing purpose. Patent किसने लिया था? US ने. फिर हमने उसको रिवोक करवा के लिया. So ये दो चीजें हुई है, हल्दी के बारे में और नीम के बारे में. It happens. Okay. That's why IPR is very important. IPR is very important. This is something related to the policies, related to science policy and technology policies, the science policy for IP as well as means your IP policy, intellectual property policy for these two, fact, science and technology. So the main focus is production of scientific knowledge, protection of science and technical knowledge. Very important about the technology is about commercialization of technical knowledge. So whatever means the scientific and technical knowledge gathered, then it is converted to some product, and that means you need the technology to design and develop it. So commercialization of technical knowledge is very important because it should convert into some API, it should convert into some WhatsApp, it should convert into some WhatsApp API, it should convert into some ChatGPT type of module, it should convert into some Skillbot type of module, it should convert into some, you should have the softwares like Turnitin, Authenticate, which helps us to check the similarity from the documents. These are all commercialization of technical knowledge. And it deals with the framework conditions among components of innovation system. So it is influence, but it is influence education policy, budget allocation, research policy, and the funds. Very important is funds. Then there are certain international intellectual property conventions. Sometimes when we file the patent, it checks it available for the global access, and anyone can file. No, you cannot file this patent. Already the innovations has been done by something else. So these are all things where one need to present it, defend it when the hearing comes. Even in the trademarks, it may happen someone had already used the logo and you had again designed the same. Again those laws are there which protects their inventions. Okay. So there is a competition policy, trade policy, industrial policy, national innovation system, the intellectual property system, and always a legal system. I think ये सब हुआ है आपका. So the key aspects of intellectual property rights for engineering faculty, one should understand the IPR, then fostering the innovation. मैंने अभी आपको दो examples बताए. It happens because it comes when you talk, you discuss, and you experience. Then protecting the intellectual assets, how one can think of. Then commercialization of IPR, navigating legal and ethical issues, teaching and training. Today's most of the time, the research is going on in the area of this bioinformatics. Normally, the bioinformatics is increasing day by day. Second parameter is about this anxiety and the stress analysis. This is also day by day increasing because the user, main concern is the user. You may have seen Might be I may recommend you to visit sometimes Sign, IIT Bombay, and see. They have come up with different products idea. एक डायलिसिस की मशीन आपने देखा होगा जो कि बहुत सारे लोग अफोर्ड नहीं कर सकते, बट IITians had come up with that particular product, make it so comfortable and adaptable and affordable कि 10,000 में भी वो डायलिसिस होना चाहिए. सो आपका पैटेंट, आपका आविष्कार इस तरह से होना चाहिए कि लोगों का पैसा बचना चाहिए और लोगों का इलाज भी होना चाहिए. इलाज इन द सेंस इट कैन बी एनी पर्टिकुलर असिस्टेंस विच यू कैन गिव बैक टू द सोसाइटी. ओके, दिस आर द टू इम्पोर्टेंट. सो इसीलिए बोला कि whenever you are filing anything else, just think multiple times whether it is going to be converted into some commercial or not. If it is going to be converted into the commercial idea, into the product idea, where you will also get in returns the royalty. What you are getting in returns, you are getting the royalty. ये अपना जो fan है, fan का जो अंदर, you know the capacitor is there. We normally change the capacitor to improve the speed of the fans. Many times happens. Who hold this patent? ये आपका असाइनमेंट है. आप ChatGPT को मत पूछना. Is it hold by Indian or is it hold by someone else? Who had? Crompton Greaves का एग्जाम्पल लेके मुझे बोलो. Sometimes you have the mobile handset, okay? So you can search and then tell me who holds the patent. Okay? So these protecting intellectual assets are very important. Who is going to hold it? Okay, because economy and the GDP of the particular nation is again depends on, this is one of the important factors which is contributing to improve the GDP of that particular nation. The commercialization of IPR, if it is held by the particular nation, then this can be commercialized. This can be commercialized. Any particular idea, like I think you may have visited Star Bazaar multiple times. You have that, क्या बोलते हो उसको आप जो कैरी करते हो उसके लिए क्या बोलते हो? ट्रॉली. द अर्लियर ट्रॉली डिजाइन एंड टुडेज ट्रॉली डिजाइन. टुडेज one can have the small baby, the trolley is designed in such a way that the baby can sit and you can continue your purchase. Is there any change required? Is there any change required? Is there any way this can be used by a person having some differently abled issues? By the person who is already on a wheelchair. A person who is already on a wheelchair can do purchase. Think it. ऐसे सोचो. You can come up with the good idea. Okay? जिसको now today's wheelchair are really good. They have the camera, but today's wheelchair cannot detect accurately the movement from the iris of the person. They have the hand and they have the buttons. They can move forward, they can move back, they can move left, they can move right. But if they do not have hand in work, then how the movement from this wheelchair is possible? Give a thought. Give a thought. Something should come out. That is where you can say something I need to do which is not visible. There, that's the innovation. जो दिखता नहीं है वही है innovation. जो दिखता है वो innovation नहीं है. सोचो. Then navigating legal and ethical issues, and then teaching and training. One should explain this part. Then roadmap for implementation, from engineering perspective, from education perspective, one should establish the IPR cell at the institute, develop the institutional IPR policy, because we would like to enhance this from the education institutes itself. Integrating the IPR into the curricula might be this particular intellectual property rights is it's necessary and need to be mandatory, the part of your education system into the curricula. Then only this mindset, these students are so brighter than all of us. Whosoever is the faculty here, whosoever is the faculty above 40, these are more powerful and more brightest than all of us, because they got all those resources which we hadn't received, and they are keeping themselves so upgraded. They are on Insta, they are on LinkedIn, they are on Twitter, they are on Facebook. ऐसा कोई भी सोशल मीडिया नहीं है जहाँ पे वो नहीं है, और यही सोशल मीडिया पे दुनिया भर के प्रॉब्लम स्टेटमेंट्स आते हैं जिनके दिमाग के अंदर आते हैं, बट उनको कन्वर्ट करना किसका काम है? हमारा काम है. दैट्स वाई दिस IPR, develop institutional IPR policy, integrate IPR into curricula, then only these ideas may convert into some product, may convert into some trademark, may convert it into some copyright or the patent. So encourage some ideas may convert into the entrepreneurship also. In my college, in SPTBI, Gayatri Noch, there is one company, there was one startup which is now stopped, but they had designed the device to detect the DNA, complete DNA from the saliva. Saliva say they completely detect the DNAs. But that startup was sold later on. There are so many such ideas, and there are so many good ideas are available in the Idea Lab. People can go and visit, see how they are converting into the product. Okay. So you can encourage such ideas and can be converted into the entrepreneurship idea. You can go and have your own product, and you can have your own startup also, if these ideas are good. Might be many of you, most of I think there are the girls, many of you would like to see beautiful. Whenever you look at, you do not find the mirror, but you had the mirror with you. Anybody can identify? Everybody had the mirror with you. Selfie. Is the selfie is not the mirror? Is the mirror. Everyone would like to see beautiful. Many times you see, अरे यार दाग कहाँ से आया? अरे यार ये काला दाग कहाँ से आया? You want your skin is looking good. Are you using any particular app? No, but are you thinking ना something, if अगर कुछ हुआ तो इसको कैसे अच्छा करने का? So you should come up with those particular application. You should come up with those application which helps these peoples to understand the skin analysis. You can come up with those ideas, and you can go to Cure Skin. Cure Skin help you to understand if you have the melasma, you have the acne, how much, and then you can move ahead with the possible treatments. So these are something which can be converted, and the entrepreneurship can be begins. Collaborate with the industry, monitor, and then finally evaluate. So this can be, see, one simple idea, if it is really has the commercial value, can take that particular institute to have one particular entrepreneur, and one particular entrepreneur can provide more than 1,000 jobs. This is what is contribution back to the society. एक idea, एक दिमाग के अंदर की idea अगर रियली इनोवेटिव है, एक क्रॉम्पटन ग्रीव्स का जो कैपेसिटर है वो इतना पावरफुल है कि एक अगर इनोवेशन हुआ तो एक प्रोडक्ट बनाने के लिए पूरा आपको कंपनी तैयार करना पड़ेगा, और एक कंपनी के लिए आपको इतने सारे एम्प्लॉयज लगेंगे. सो वन सिंपल पैटेंटेबल इनोवेटिव आइडिया may create lots of employability in the nation. That's an impact. I think you may take it very positively. Theoretical lecture है, but एक simple idea, एक innovative idea कितने सारे jobs create कर सकती है, इसका याद रखो. It is so impactful. Do not take it lightly. I know at this stage not possible, but one simple idea may convert, may give lots of employability to the people. Is it not the goal of your life? If you are helping someone to change their lives, that's the goal. Keep in mind these particular objectives. You can do this. You need it, very important to understand how to file it, how to prepare it, how to identify it. You have the mentors and the teachers at your institutes. You have the lawyers, you have the patent experts. You can verify, you can get this idea verified, and if it is really fine, feasible and commercial, go ahead. The institute should support such ideas so that it will be converted into the product. In our college was Rahul Chari and Samir Nigam, the electronics guys, have come up with the idea of banking systems and have a simple, you know PhonePe? PhonePe is SPIT startup. Mr. Rahul Chari, our 1999 passed out. कुछ क्या था ना, idea how to make the payment using mobile devices. Those days, Now it is more than, see, where this phone pay reaches. How many jobs he had created? How many jobs he had created? More than I think 1 lakh. More means at different levels. Work India, AI Praise, more than 50 such startups are there who are providing the jobs. So that's why this is what is the final aim of the institutions to support to the society in terms of, it is linked with the IPR. They hold those IPRs, they hold those copyrights and the trademarks, because unless they don't hold, how it can say that it's an Indian company and how it will add the value to the GDP of my country? It's also important. Intellectual property rights, the types of intellectual property, it refers to creation of the mind, such as inventions, literary and artistic work, designs, symbols, names and images used in commerce. Some of you are very good in designing, some of you are very good in icons designing, maybe many of you are good in drawing rangolis. Have you seen mathematical rangoli? Mathematics rangoli by using Pythagorean theorem? है ना, गूगल में देखो आप, एक मैथमेटिकल फार्मूला यूज करके रंगोली बना के रखे, जस्ट चेक इट, है, it is there. I see you want to say this is all about calling about the symbol designing. You may have very means exemplary symbols, you may have abstract types of symbol, icons जिसको हम लोग बोलते हैं icons, might be in on your shorts, there are so many designs and everything are there. Many times you have seen the word R in round, registered, TM in round, trademark. These are all copyrighted. C in circular, copyright. Many times in website you have seen it is copyrighted, it is trademark, it is registered. McDonald's, R or TM. These words cannot be used by the people because government has granted them. This is protected. This is an identity. You are the owner of this particular name. You are the owner of this particular symbol. You are the owner of this particular logo. Others cannot copyright. Okay? Resulting from any scientific, literary or artistic production of which he is the author. That's Article 27 is very important to understand. Although the relationship between IP and human rights is a complex one, there are moral arguments for intellectual property. बहुत बार hearing ऐसे ही cancel हो जाता है, बहुत बार हो जाता है intellectual. ऐसे कैसे कर सकते हो बोले आप, ऐसे कैसे डाटा लेके आप बोल सकते हो कि ये मैड है, ये सैड है, ये हैप्पी है. बहुत सारे जो पब्लिक होते हैं, पब्लिश्ड होते हैं, वो ऐसे ही रिजेक्ट हो जाते हैं बिकॉज मॉरल्स ह्यूमन लॉज जो है वो फॉलो नहीं करते. या समटाइम्स इन सम एप्लीकेशंस दे हैव नॉट टेकन द एथिकल परमिशंस, institutional ethics, because anything cannot directly apply on the human being. Keep in mind, अगर ह्यूमन बेस्ड कोई सोल्यूशन आप इन्वेंट कर रहे हो, ह्यूमन बेस्ड कोई डिवाइस अगर आप डिजाइन कर रहे हो, ह्यूमन बेस्ड डायरेक्टली, टेक्नोलॉजी कैन नॉट डायरेक्टली अप्लाई ऑन एनी ह्यूमन बीइंग. नो, ह्यूमन मॉरल्स वही कैंसिल हो जाता है. सो वो बहुत इंपॉर्टेंट है कि भाई ये किस तरह से है. सो ये आपको सोचना है. सो मॉरल, so laws to protect intellectual property, there are international convention, that is trade related aspects of intellectual property rights, that is called as TRIPS, TRIPS, trade related aspects of IPR. Then Indian copyright, these are all the laws used for protecting the IP. Indian Copyright Act है 1957, Indian Patent Act है 1970, Indian Trademarks Act 1999, other acts 2000 से डिजाइन एक्ट है. सो मेनी डिजाइन पैटर्न्स आपने सुना होगा, डिजाइन पैटर्न जल्दी मिलते हैं. ओके, डिजाइन एक्ट 2000, सेमीकंडक्टर इंटीग्रेटेड सर्किट लेआउट डिजाइन एक्ट, सेमीकंडक्टर के लिए खास बना ये लॉ 2000 में. सो दीज आर दी लॉज विच प्रोटेक्ट्स द आईपी. अरे Okay, these are the laws to protect the IP. The next point here is about this in detail. What is TRIPS? TRIPS is an international legal agreement between all the members nation of World Trade Organization, and it is established a minimum level of protections that this World Trade Organization members were required to provide intellectual property of other member. It covers copyrights, trademarks, patents, geographical indications, that is GI, industrial and layout designs, and undisclosed information, that is trade secrets. This TRIPS, which is international law, is a minimum standard agreement, allows members to provide more extensive protection of intellectual property if they so wish. And members are left free to determine appropriate method of implementing the provision of agreement. Okay, because it involves royalty, it involves money, it involves where the production house will be there at this nation or that nation. That's why this international law is very strict. Okay, the types of IP, that is non-traditional intellectual property and traditional intellectual property. Non-traditional IP, you can see trade secret, circuit layout, domain name, so many domain names we normally do, this.com, this.in, yourname.in. So these are all non-traditional IP, okay? There is no such. But if you want, you can apply for copyright, you can apply for intellectual property. If you want this something like shadi.com, you can check it whether it is non-traditional IP or traditional IP. Naukri.com, workindia.in, you can check these websites and see what is the difference. Okay, but because some it is not necessary that your identity can be patented sometimes, like your name, domain name, some designs, plant varieties, different plant variety. कोई बोलेगा क्या कि नहीं ये हिबिस्कस का मैं पैटेंट लूँ, हिबिस्कस मैंने बनाया है? नहीं होगा ना, ऐसा नहीं हो सकता. कोई पर्टिकुलर प्लांट है और वो बोलेगा कि नहीं ये मेरे गार्डन में आता है, मैं इसका पैटेंट करता हूँ. इज इट पॉसिबल? नॉट पॉसिबल. सो दैट इज ट्रेडिशनल आईपी में है द स्पेशल केसेस लाइक वेयर द प्रोडक्ट, योर आइडिया, योर इन्वेंशन having the commercial value, commercial aspects can be prepared for patent, trademark and copyright. The trade secret here also called as IP or proprietary information, which is the term used for any method, formula, the device. आपने सुना होगा Ohm's law, current law, so many Kirchhoff's law, mathematical formulas, so many different formulas you may have used, method, formula, device, process, or any information that gives the business a unique competitive advantage over its competition. Anything that gives you advantage against the competitor is highly valuable and worth protecting. So these trade secrets come in the endless array of types, like it can be your R&D information, software algorithm, invention, design, formulas, ingredients used. Someone can say ये मेरे ingredients थे उसके वजह से वो उस तरह से हुआ. So those ingredients can also be you can file the IP. Your methods, your devices, maybe the device is same, but the material used for the device, the control systems used for the device, the expert system designed for the device can be yours. So you can file those. You can file those. You see, अभी ओला भी है तो उबेर भी है, तो बहुत सारे हैं. ओला भी चलता है, उबेर भी चलता है, क्योंकि कंज्यूमर्स बहुत है. रेस्टोरेंट्स देखो दुनिया भर के बिकॉज कंज्यूमर्स आर so many. So you need to think it very wisely where and how the idea can be formulated. Okay, trade secret is information that is not generally known to the public, and it confers economic benefits on its holder because information is not publicly known. Examples of trade secrets include KFC सबको पता है, KFC's secret blend of 11 herbs and spices, KFC. Then Coca-Cola's recipe of their signature drink. Then Google's, these are all trade secrets they have already obtained. Okay. Then Google's search algorithm is also one of the search algorithm, the Google. When you type Google, the search text box comes. That is also the property of Google itself. One cannot say. अगर आप Google search engine आप अपने website में use करो, इसका मतलब वो आपका search engine नहीं हो जाएगा, वो Google का ही होता है. That is what is the trade secret. McDonald's Big Mac, वो तो आपने देखा होगा, बिग मैक लिखा हुआ, बिग मैक स्पेशल सॉस, सीक्रेट क्लाइंट लिस्ट एट एनी कंपनी, दैट इज सपोज टू बी योर ट्रेड सीक्रेट. नाउ द कंसिडरेशन फॉर पैटेंट एंड ट्रेड सीक्रेट. सी द इन टर्म्स ऑफ रिक्वायरमेंट, पैटेंट रिक्वायर्स इंटेंशंस टू बी यूजफुल, नॉवेल एंड non-obvious. While in trade secret, no such requirements aside from being secret and having economic value. In with respect to subject matter, for patent, yes, it is restricted. Patent के लिए subject matter is restricted. For your trade secret, it is not restricted. Duration for the patent, it expires 20 years from filing the date. फाइल करते हो उसके बाद 4 साल में आपको मिलता है, उसके बाद 20 साल तक वो रहता है, उसके बाद आपको रिन्यू करना पड़ता है. ट्रेड सीक्रेट इट इज प्रोटेक्टेबल फॉर एवर. ट्रेड सीक्रेट इज प्रोटेक्टेबल फॉर एवर. लाइक गूगल सर्च, it is protectable forever for them. Coca-Cola, bit protectable forever. That's the difference between patent and your trade secret. Process for obtaining the protection for the patent, placing invention in public domain via patent application. हमें वो application public domain में submit करना पड़ता है. It got search and hit. सब बोलते हैं ये ऐसा कैसे, ये तो मेरा, इसने तो मेरा ही कॉपी किया है, ये तो मेरा था, मैंने तो पहले का करके रखा है, इसने तो अभी पैटर्न. so many such searches comes और बड़ी लिस्ट हो जाती है. और फिर कंट्रोलर को लगा ये तो यार सब लोगों ने ऑलरेडी करके रखा है, वहीं पे अबेंडेंट हो जाता है, आता ही नहीं है हियरिंग के लिए. वी आर डिफाइनिंग एंड ट्राइंग टू जनरेट और डिजाइन और डेवलप यूजिंग AI इज एक्सेप्टेबल और नॉट. AI systems generate the code. AI can generate art, text and music. The legal ambiguity is always there. Who knows who owns the AI generated outputs? So patents protects invention as long as those inventions, those are novel, involved and inventive steps, are capable of industrial application and do not fall within certain excluded subject matter. This is what actually. So everything which you can say today's ChatGPT is very simple to get 4 beautiful, 5 beautiful innovative ideas and can be, but there are important aspects. ये आपका हुआ है. See, दो प्रकार की AI. One, you can different analysis for IP protection. First is AI output. Second say AI system that creates output. So Dell E2, that is new chat, and again you have ChatGPT 3.5. ChatGPT itself, they had filed the patent. And that is a trade secret, the ChatGPT, Mr. One, okay? So IP challenges in AI, ownership of AI work. Can AI generated work be copyrighted? Example, Dolly painting, yes or no? Yes? Can AI generated work be copyrighted or not? Yes. Copyrighted is normally on the particular articles, okay? Copyrights divisions doesn't check how it is generated. It can be copyrighted. Patents and inventorship. Can AI be patent inventor in case of this Dabu's case? These are certain critical examples I am presenting. IP challenges in AI. IP, intellectual property, has a challenge because AI is not inbuilt, AI is not in place, and because of not having the use of AI, it's very difficult to understand whether AI is generated or human being is generated. That's why I'm saying. Training data issues, risk of copyright violations. Example, GitHub Copilot. Nobody is going to check from where this data gets collected, because I know in the hearing system, the patent attorney doesn't check whether it is from the GitHub or from the GitLab. No idea. No, I am talking about the GitHub. GitHub is a repository where not only the data, but code for the system, code for that application is also stored. So while hearing, patent officer never asks where this data available. That's why I am asking. It doesn't never ask because it is not in their policy. It is not written somewhere else that no data should not be there in the GitHub. That's why that DOMs are missing. So people nowadays are getting stored in many of you students are storing your data, storing your code on GitHub. And when you go to the hackathon, are you going to write a complete code? No. What you are doing? You are pulling and saying this is mine. Yes or no? Yes. Deepfakes, mimicry without consent. Example, AI generated voices. Deepfakes करके एक है. Deepfakes itself. Deepfakes एक बनाया है टूल है, AI टूल है, जो कि AI यूज करके आप किसी का भी वॉइस जनरेट कर सकते हो. किसी को 30 मिनट्स का अगर प्रेजेंटेशन बनाना है तो आप वो प्रेजेंटेशन, वो एक्चुअली these are the proprietary tools which helps you to convert the male voice to female voice to male voice. Have you seen that? It is there. So these are the IP challenges in AI. That's it. Okay, most IP laws requires human authorship. AI generated works not protected unless human input is significant. And patent offices deny AI as an inventor. Patent offices, whenever the keyword, your keyword AI comes, there itself they say, yeah, somewhere they have an influence of generating the contents using AI, so it gets rejected. AI cannot be an inventor. US Constitution laws requires a human be the inventor. AI output is a creation of human inventor, someone say, okay? Open sourcing licensing in AI. AI is heavily relies on open source code, data and tools, and licensing issues can arise during model training and deployment. So about the open sources, there is no certain restrictions of not using the open source code. It is available. If someone can use those open source, it is, yes, there is no such law, means there is no restrictions as such. That's why it is open source licensing in AI. You can use it. The license violations, AI may replicate GPL code. Yes, it is possible that the co-pilot code can be replicate. Ambiguous datasets licensing, datasets may lack permissions like ImageNet. कोई नहीं पूछता है ImageNet से permission लेने का. ImageNet is a collection of all of us, including me, you, cats, mouse, dogs, plants, everything. What you want? Which type of classification you want? You just say, I want, you are using image, say ImageNet values, weights values. ImageNet is a weight. ImageNet is what actually a database having the weight. Based on the weight values, it classifies. You give me dog, I will give you, yes, it is dog. You give me mouse, I will give the mouse. That is what is the ImageNet. There is no restrictions as such. One can demarcate. Means I would like to say, if someone is coming up with an innovation where this ImageNet database and the weights are used, it is not going to get checked and detected. So you can use somewhere very wisely where this keyword need not to be sometimes presented, because no, it's here ambiguous data science license, because it is open source. If it is open source, it can be used. Model weights licensing, Metos, Llama may restrict the usage. जहाँ तक है वहाँ तक है. एक tool था, and it was then I think one of the company has already purchased it. It's a big company. I not remember the name of that company, but earlier it was completely free. Few days, 3 years to 4 years, it was free, and then it was taken by some company. So इस तरह का law, model weights, sometimes they give just free licensing to the user, checks whether this is most usable or not, and if it is observed it is most usable and powerful, then it is gets commercialized. Then some methods, one of the challenges is derivative models. Fine-tuned versions might be restricted. Some derivative based, some derivatives which we cannot say, if it is already derived somewhere else, one cannot be said. So this is again one of the challenges in open source issues in AI. The open source softwares with AI, like open source licensing impact, incorporating open source code into your AI software may require you to give away your copyrights, your patents, source code, as well as your AI creation. But be strategic. Open source code is easy, but keep it away from software that include the key IP of your company. Protect your trade secrets by not using open source software where this particular code you want to keep as a trade secret. We are at the end only now. Common open source licenses like MIT, Apache, it permissive and easy to integrate. It is okay. It can be used. GPL, AGPL, strong copyleft, derivatives must be open. These are some common open source licenses which can be used for common creative, innovative practices. Then some key takeaways like AI and copyright ownership unclear. AI and copyright ownership unclear because there is a legal laws. AI and the public domain, AI creations cannot be protected under copyright law or patent. AI creations are in the public domain, free for anyone to use. You can use it, but you cannot stop anyone else from copying or using it too. चैट जीपीटी से किया हुआ समराइजेशन आप किसी को प्रोटेक्ट नहीं कर सकते हो अनलेस यू डू नॉट हैव द स्ट्रॉन्ग रीडिंग एंड नोइंग वेदर इट इज रियली ओरिजिनल और नॉट. Finally, at the end, human being like me and you are depending on third-party software. And third-party software is also depends on the data sources that it had. If it is not, then you and me cannot check. Okay, these are certain key habits. Not about copyright, that's okay. How do we protect AI with weak copyright and patent? Like trade secret is the winner with weak copyrights and patent. Trade secret is more powerful as compared to your patent. The business model supporting trade secret is software as a service like SaaS. SaaS model आपने सुना होगा. That is also one. The business model. SaaS is a business model which is trade secret. It's a cloud application software. SaaS is a cloud application software available to its customer via internet on a pay-as-you-go-on basis. On pay basis, it is available because it is on that particular cloud. SaaS software provided through GUI from the cloud. So this is the trade secret. One can go for it. One cannot say that if somebody would like to take the inference from particular software application which is available on this particular, then that person can say this is my proprietary application. This is my trade secrets. Okay. Patents, no AI inventorship. So how do we protect AI without patents and copyrights? Like trade secrets are IP rights on confidential information which may be sold or licensed. The information must be commercially valuable. Because it is secret, it should be known only to the limited group of person. It should prevent unauthorized acquisition. The example is given, how do we protect AI without patent? That is SaaS. Licensing agreement is there and open source licensing is also there. Okay? Because open source licensing is helping them to use freely. You can modify it, you can share it, you can distribute it. So finally, data use, there are so legal gray areas. The potential copyright issues will be there. OSS, that is open source licensing, risk of violation, and it is liability of the developer to use the OSS up to the particular level. Mitigation strategies, I think ये हो गया होगा आपका. So as AI evolves, so much legal framework should also be. Ethical and legal awareness is essential for sustainable AI innovation. Still, it is not there in the policy too much. Okay, now it is amending. IP protection depends on whether it is AI system that creates output or AI output itself. AI system that creates or it is an AI itself. No protection under patents or copyrights for AI generated outputs. What about increasing human interaction in creativity? Maybe line not drawn here. IP protections for AI system includes your patents, copyright and the trade secrets. The trade secrets go to IP protection for AI through SaaS as copyright, and patents have seen strength of protection weakened in the federal courts. When protecting software as trade secret, watch out for incorporating the OSS. That's it. I think many of you had already shown how the patents can be filled, the trademark can be filled, how the copyright can be filled. I think then that is enough, because see, when we talk about, I think told you some simple good ideas that how these innovative ideas can be identified, which is not visible. It is not visible how it is possible. But you can think of, and this is how one need to do study, a strong literature review, study of existing app, existing designs, existing devices, existing machines, existing architecture, existing frameworks. So many need to do study, and then only you can give those flavors, say something like, yeah, it is something different which is not exist. And then you can move ahead, but always put the efforts with the aim that after filing, you should have some guarantee of getting it patented. Patents granting in India is a challenge itself. Yes, sir. Patent granting in India, it's a challenge. Granting any patent is really a challenge. The one of the patent which we had filed is what about the healthcare based IoT. What we decided that when a patient was in the ambulance, there should be an IoT device. This is before 7, 8 years back. Why not to track the patient's health, patient's vital parameters remotely? It was completely new. Medical IoT, medical MIoT, the name was given MIoT. It is still under consideration. I don't know whether it is abandoned or not. Hearing has been done, everything has been defended, it's done. The another devices we had come up with might be Gayatri knows about the elderly people, remote health monitoring of elderly people, remote health monitoring. So in the remote health monitoring idea, the idea is come up with the new small design of a circuit having some sensors which is already there, which we are not going to say this is our, but we can say the complete layout, the complete design. It's a design patent. We had applied for the design patent, and now it is in hearing. Hearing has been done, and we are waiting. On one click, how the different parameters, different vital parameters can be easily accessible via WhatsApp, via SMS. So if your elderly is at home and you are at the office, you can constantly keep monitoring the vital parameters of the elderly person, because elderly person, at least you can say reminder. You can have a reminder, Baba, please go and keep the finger on the device. Baba, go there and keep the finger on the device. When Baba keep the finger, you will definitely get the 3 important vital parameters, assuming, oh, it's fine. Heart rate itna hai, temperature itna hai, I can go and go to the home properly. Is it not the good idea? That's a good idea. Is there available now? Is it available at your handset? Can you remotely monitor the vital parameters of the elderly? No, na? So I had defended it, heard it, but patent is not yet granted. So Indian patent is very, means, I can say, I don't know, maybe there may be flaws or there may be drawbacks from my side itself in terms of, but it is properly framed with the help of a lawyer itself. The designs, the proof has been given, the proof has been shown, everything is working very, very nicely, waiting whether it is going to be granted. But getting the patent in India is really challenging. I am waiting one patent since from more than 7 years. But I also surprised, without any hearing, sir, without any hearing, I have this patent available with me without any hearing. The big data architecture, I can show this. This is what actually मैंने निकाल के रखा था. This one, this article, this one. The name is big, पढ़ा होगा आपने? Simple name, big data architecture for predicting malaria and dengue incidents. This is what I got granted without any hearing. Without any hearing. I don't know why. I don't know the reason. So can I say it is innovative? Can I say it is completely new? Because I also fight for this. I fight initially, but I got it. I just fight in terms of whether it is innovative or not, getting validations from KEM itself. We are the 3 people, one from KEM, one was the PhD student, that is Dr. Asha Bharambe, and one is mine. This was the architecture. So here you can see in the diagram, hospitals, social media, internet, laboratory, and it's a complete framework. It's a complete big data architecture. If someone would like to go for such kind of incidents handling related to your mosquito and dengue, malaria, such this architecture will definitely helpful for any organizations to think of designing their application, and that's why it was granted. This is again before 6 years back. This is what actually. There is nothing in the keyword, na? You have this big data architecture for this, nothing. But the architecture talks more about the interconnections of the various modules which we have thought of for a particular company to go means to use this architecture for designing your application. So that was this one thing. That I think this is from my side. There are इसमें बहुत कुछ है बोलने के लिए, but there are so many things to speak. You can ask me anything related to the technology, related to the image, related to your artificial intelligence. Our one project is just initially started with Bombay College of Pharmacy. Bombay College of Pharmacy, and we are thinking of having the gamification unit using augmented reality and virtual reality. It's not simple. It's not simple because just thought of. So come up with those gamification unit which helps the elderly sitting at your home to get recall of the past incidents in order to reduce the dementia. In order to reduce the dementia. It's so difficult. So we have to take this challenge.
Can we patented this if I have purchased that subscription and all? Not AI, not using a AI, but some applications are available.
Some applications are available, but whether the applications is designed by you using some available software like React, and you are using front
Like
end and back end.
like Canva, poster my wall.
Canva, no. Canva itself is a proprietary. Canva itself is the copyright. So someone which already you are using, already you had using a proprietary software like Canva for designing your own, cannot be used.
Thank you, sir.
This is completely drawn on the paper itself. This diagram, nothing means it's what as an architecture. It's a thought. What should be the best architecture to go with? To go with big data architecture. Here it involves many techniques. If you can see, I can tell you, it is risk map. Okay, correlation analysis, regression analysis, time series analysis, clustering, association analysis. It goes to build model and model improvement. Here we have pre-processing tasks, data cleaning, data normalization, data representation. We do study of the existing architecture. That is not, we have written it, but it was completely new in the context of using the big data architecture for malaria and dengue in the Indian settings. I works very closely with the Department of I think Center of Excellence in Basic Science with University of Mumbai, at least for 3 to 4 years, records of 7 to 8 years. We had used all mathematics and come up with a map, heat map in Mumbai showing this area is suffering from hepatitis B, hepatitis A. I know, I cannot disclose this right now here, but I know. But those data I forgot because it was not allowed, because it's a government data sets where the samples from all over Maharashtra came, that is blood samples, based on which how many dengue cases from which particular district, from which particular tahsil, from which particular village was there. That's a beautiful data set. If someone would like to go ahead with this, please go and talk. They had the data set, and you should have your own way, because मुझे restrictions था उस समय, but I did it, and I know in Mumbai कि कौन सा place में कितना क्या है, I know, but I cannot disclose it because of some restrictions in myself, because I promised. Yeah.
Sir, when we work on any project, how to decide whether to go for patenting or for open licensing? Because
in any project, if your idea is completely you observed is new one, you should not publish it first. You should not make the data available. You should not present the paper, as well as you should not present it in some seminar hall unless you file the patent and guarantee that you are going to get it back. That's one. If it is really, you need to search it, because you need to study the existing methodology, existing architecture also. And if you are doing the same thing which is already exists, you do not go for patent. should not go for the patent.
Okay.
And another things, if you say that you are going to create some economical value, you want to have your own startup, you want to commercialize it, then you can go with the patent. लिज्जत पापड़ भी है और घर घर में भी पापड़ होता है, तो लिज्जत पापड़ ही क्यों हमेशा खाते हैं हम लोग? बोलो, क्या लिज्जत पापड़ ही एक पापड़ है जो हमें अच्छा लगता है? क्या घर के पापड़ अच्छे नहीं लगते? बोलो बोलो, है ना? That's what. So this is what Lijjat Papad's trade secret, you can say. And it everywhere sold, everywhere gets sold. अभी लोग घर में नहीं बनाते हैं Lijjat Papad. So that's what commercialization. Think in terms of commercialization. If you see your idea will create the jobs, having the commercialization value, having those aspects, then this patenting and putting efforts in patents, but taking further to the next step is very important. Otherwise, in like a teacher, I had this patent, but I am also lacking. I do not have those skills, how I can scale it up to the next level and make it more money. This is also one thing. I accept it. See, teacher के पास idea बहुत होती है, ये करो, वो करो, ऐसा करो, वैसा करो, but सब idea commercialize होके एक startup के form में convert होके, it should go to the next stage, creating the employability. It's a challenge itself. बरोबर ना?